The next bill on the calendar for the day is Senate File 1384. The clerk will report the bill.
Senate File number 1384, number 1 on the calendar for the day, an act relating to state government, modifying labor policy provisions, the second engrossment.
Representative Nelson, I have a DE amendment. Would you like to offer that now?
Yes, Madam Speaker. The DE is mine. It puts the House language into the bill.
Nelson moves to amend Senate File number 1384. Second engrossment as follows. Delete everything after the enacting clause and insert the following languages of House File number 1522, the first engrossment. And the amendment is coded DEA 1522.
Representative Nelson, to your amendment.
Madam Speaker and members, this is the House policy, or the policy bill for the Labor and Industry Committee this year. Yep. And it contains multiple bills from multiple members.
So, yeah, thank you.
We have a bill from Representative Jordan, Representative Greenman, Representative Berg, a couple from myself, Representative Kraft, Representative Newton, and Representative Hollins. What this bill does is it has updates to PELRA PELRA laws. In this bill, it prohibits restrictive franchise agreements that prevents free movement of employees. It prohibits employers from firing, disciplining, or otherwise penalizing employees because they refuse to attend what they call captive audience meeting having to deal with religion or politics. It modifies some OSHA regulation. It updates some energy codes, including refrigerations, which instructs Department of Labor and Industry and the code enforcement part to allow some new products that have come along for refrigerants as they come on the market and are approved by the feds. It updates, there's also the elevator bill in there that I've been dealing with for the last couple of sessions that currently there was some overlap in work that's assigned to the millwrights and the elevator constructors. This deals with that, and these are conveyors, elevators, and platform lifts. And what this came out of, if everybody's seen the Carvana commercials with, I call them the car gumball machines that they have some places in the country, well, there's some fight over whose work that is and whether it needs a license, an elevator license or not. And this bill deals with that. It's an agreement between the two unions and worked it out in the language so that they're both happy with it. There are some changes to the Board of Electricity and the Board of High Pressure Piping Systems, and these were worked out with the locals, the trades involved, to make sure that the proper people are on these boards. Exempts some load controls replacements that are done by public utilities from inspections, and if they're done by a licensed electrician. And these are, I call it NSP, but Excel and the other public utilities around the state. And it sets up rules for sacred communities at religious institutions to have permanent micro-dwelling units to help with some of the homeless that's also out there. And man, with that, there are amendments to the bill, and
All those in favor of the author's amendment, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Greenman moves to amend Senate File number 1384. Second engrossment as amended, and the amendment is coded A4.
The member from Hennepin, Representative Greenman.
Thank you, Madam Speaker. This is an amendment to the prohibition on no-poach franchise agreements, and it adds language that was heard and amended in the Judiciary Committee to 1831, but didn't make it in the draft of the policy bill because of timing. The amendment reflects input from the franchisors who were concerned about the opening up contract negotiations as a side effect of removing the unenforceable no-poach provision. So it adds an additional option to sign a memorandum of understanding. It also includes clarifying language and notice to ensure that employees are aware when there's existing contract language that's unenforceable and violates the law.
Discussion to the Greenman amendment. Seeing none, all those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Jordan moves to amend Senate File Number 1384, the second engrossment as amended. The amendment is coded A12.
The member from Hennepin, Representative Jordan.
Thank you, Madam Speaker. The language in the A12 comes from compromises with management organizations. It clarifies that adult to student ratios are negotiable, not capital projects or the physical size of classrooms. It also gives employers more time to provide data to labor organizations representing employees. It also ensures that union representation workers adhere to worksite safety requirements. This amendment also cleans up language related to Representative Berg's captive audience bill and some language related to the franchise work that Representative Greenman did that will be amended by an amendment to the amendment.
There is an amendment to the amendment. The clerk will report the amendment.
Jordan moves to amend her amendment to Senate File Number 1384. The second engrossment is amended. The amendment to the amendment is coded A14.
Representative Jordan.
Thank you, Madam Speaker. The A14 fixes a drafting error and deletes duplicative language from Representative Greenman's amendment. I ask for members' support to adopt the A14 to get the A12 in the proper shape.
Any discussion on the A14 amendment? Seeing none, all those in favor, please say aye. Those opposed, please say no. The motion prevails. The amendment to the amendment is adopted. On the A12 as amended, any discussion? Seeing none, all those in favor, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There is an amendment at the desk. The clerk will report the amendment.
Myers moved to amend Senate File Number 1384, the second engrossment as amended. The amendment is coded A13.
The member from Hennepin, Representative Myers.
Thank you, Madam Speaker. The A13th amendment is something that we are trying to allow employees some additional options and rights. So what it is allows employees to have their employer during interviews if the employee consents, as long as there's no presence of pressure or coercion. So, I think I've done a fairly good job in the Labor Committee. When I'm looking at a lot of these bills, I try to bring an operational aspect to it and come up with ideas that both support employers, employees, and our workforce. So this amendment is just providing additional opportunities for those employees so that employers can be present. So I would ask everybody to vote green. Thank you.
Discussion on the Myers amendment. Representative Nelson.
Thank you, Madam Speaker. And members, while this may seem reasonable, speaking with OSHA about this is part of the OSHA bill, when they're interviewing employees, the presence of somebody that's your manager, the lawyer from your company, your direct supervisor or the owner of the company, whether they were coerced or you asked them to be there, it has a coercive effect on what you can say as an employee. You're afraid of your job. You're afraid you might, if you say the wrong thing, you might get let go or be punished or disciplined. And that's what this is about. When OSHA goes out to do inspections or OSHA goes out to do investigations after an accident, they need to make sure that the people they're talking to are free to talk and give the right answers and not be afraid that they're going to be disciplined for it by their employer. So I ask for a no vote on this amendment.
Further discussion. Representative Myers.
Thank you, Madam Speaker. I'm disappointed to hear that, not surprised. But I would ask if the chair would yield for a question.
He will yield. Representative Nelson.
So the question I have is if an employer at this time if an employee wants to have an employer in during these investigations, does the employer have that right?
Representative Nelson.
With the language of the bill, no.
Representative Myers.
Thank you, Madam Speaker. Would the chair yield for one more question?
He will. Representative Myers.
So if an employee is denied the right under the bill to have an employer in there, if the employee then refuses to be part of the investigation, what would happen to that employee?
Representative Nelson.
Well, Madam Chair, and I guess OSHA has I believe has the right to subpoena if there's a case, if it's an investigation for an accident. The employee would have the right to have their own lawyer as long as it's not the lawyer from the company. They also would have the right to have in a business, somebody from their union, a representative from the union, a steward, a business agent there, but somebody that's not from the company.
Representative Myers.
Thank you, Madam Speaker. So the language I was trying to provide was to ensure we didn't have to go a subpoena route, that the employee had an opportunity and they had those options. And that's why you said, on its face, it was, good faith, and I think it is. So I would ask members to vote green on this because it is providing employees another opportunity. And, I'm trying to look here to make sure that we have those situations that do arise, because I have heard from employees that say they would like to have their employers in there on those. Again, that's why I put the language in there of coercion or pressure. So I'd ask members to vote green.
Any further discussion on the Myers amendment? Seeing none, Representative Myers.
May I ask for a roll call?
Representative Myers requests a roll call. Seeing 15 hands, there will be a roll call. The clerk will take the roll on the Myers amendment. The clerk will close the roll. There being 61 ayes and 69 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Kresha moves to amend Senate File number 1384. The second and Grossman as amended. The amendment is coded A11.
The member from Morrison, Representative Kresha.
Thank you, Madam Speaker. And members, the A11 amendment seeks to build better relationships and trusts in our school districts and among the bargaining units with the administration and management. What I'm removing here is many of the provisions that are added to this bill that simply try to get in the way of that process. And those of you that may have been in negotiations on either side or both sides know that those negotiations are critical to the relationship and the smooth running of that organization. And there's a number of provisions in here that I delete with this amendment to take those provisions back into the local organizations and let them work through these very critical issues like class size and all the things that are pertinent to a school year. But one particular section in here that I want to talk about has to do with the Janus decision and fair share fees. And let me tell you a little story of a teacher that I knew. A young teacher started off his career and he was teaching 3 hours in the morning in language arts. Just married, brand new child. That teacher then left, went home, had lunch, came back, and was a custodian. After school, that teacher was a coach. And then in the evening, that teacher would go and work at the local newspaper. Was working 4 jobs early in the career just to get this young family going. The problem was the teachers' union wanted to fair share this person and did fair share them. The custodian union fair shared them for the afternoon. Even though this teacher did not want to be part of either bargaining unit, not because they were looking for the protections or the benefits that go with the union, but because this teacher simply couldn't afford diapers. Both of these unions made the arguments, fair shared them, and the provisions in this bill, that teacher could not go back and recoup what frankly were illegal fair sharing practices. Members, by putting the language in here to remove that, not only are we getting in the way of what's happening with bargaining units, we're getting in the way of courts. These issues should be decided by the courts, not us in this chamber. And every time we insert ourselves, frankly, we make it harder and we get it wrong. So with that, Madam Speaker, I would ask for a roll call, and I would ask you for a green vote on this amendment.
Representative Kresha requests a roll call. Seeing 15 hands, there will be a roll call. Discussion. Representative Jordan.
Thank you, Madam Speaker, and thank you, Representative Kresha, for the discussion. The A11 does much more than that. This amendment deletes all of the provisions in this bill that update PELRA. I want members to remember back to the pandemic when we called our public employees heroes. These heroes are asking for simply a voice on the job, and this amendment deletes that. As it relates to fair share fees, there has been, courts in Minnesota have determined that unions that collected fair share fees previous to the Janus decision under Abood did so in good faith, and they do not need to repay those fees. But this amendment deletes much, much more than that. As it relates to class sizes, I think the best quote I heard this year was on a different bill that would have put class sizes into statute. And this is what it said. It said, this representative said this in committee. The fact of the matter is everyone is talking class sizes in these schools. You've all been in your schools as well as I have. It is best that the teachers that teach and collective bargaining units conversations work best in those schools, and they know what they are working through the best. I agree. Those teachers know what they're doing the best. That quote came from Representative Kresha in committee. I agree with that, Representative Kresha, and that's why I would ask members to vote against the A11 amendment.
The member from Freeborn, Representative Bennett.
Thank you, Madam Speaker. And members, I'd like to speak in support of this amendment as well. And I specifically want to talk to the portions that do talk about some of the things the bill author has mentioned, such as e-learning days, what else here, the class size, student testing, student to personnel ratios. And I've spoken a lot with our local school board members in all of my school districts. And you know what they ask? They say, Representative Bennett, does the legislature not trust us? We are the locally elected school board. Don't they trust us to make these decisions locally and do what's best for our own schools and our teachers and in negotiations and all those factors that they deal with daily? And I said, it does make us, or I can see how you would doubt that. We should be sending messages that we do support our local school boards. These are the people that the families, the parents, the grandparents, all the people in our communities have elected to represent them in our school districts. We're taking away their managerial authority. And I'll just say, as a former teacher, I think class size is hugely important. I would agree with that. But as a teacher, I was not privy to all of the financial aspects of our school district and other factors that they have to weigh as they make those decisions. And so I believe that this should be left to local control. The local teachers, local school boards should be making these decisions, not being forced into it, but allowing it by the people that were elected locally. So I ask you to support Representative Kresha's amendment. Thank you.
The member from Anoka, Representative Niska.
Thank you, Madam Speaker and members. And I just want to address the Janus litigation question. And as Representative Jordan pointed out, there have been cases, and most of those have been resolved in favor of the union. So this legislation really is not necessary. It's not going to actually solve any actual problem in the real world. The only thing it's going to do is it's going to set a message that we as the legislature have decided that there is one particular category of litigation where we are going to weigh in and decide that some civil defendants in some civil litigation are more equal than other defendants in other civil litigation. I think that's a very dangerous precedent for us to set. It tramples in the space of separation of powers, and in particular, it's just picking out winners and losers in ongoing potential litigation. It's not the right road to go down. So thank you, Representative Kresha, for this amendment. Vote yes.
Representative Nelson.
Thank you, Madam Speaker and members. And again, as Representative Jordan spoke, this is about, this doesn't affect Janus. Part of the bill and some of the stuff that's being gotten rid of is access to these employees so they can, the union, the represent, bargaining, or the exclusive representative, that's the word I'm trying to get out of my mouth here, can talk to them. Without knowing the names of these employees, they can't do that. If the person says, I don't want to be in the union, they can no longer collect fair share dues. The other piece of this is stuff that's in there for bargaining purposes. And like any bargaining unit and any bargaining you do, contract negotiations, if you've ever done that, the employer can always say, no, I don't like that. We're not going to talk about that. But this makes this part of the bargaining unit, but they can always say, no, I don't agree with that, and turn it down.
Further discussion? Representative Kresha.
Thank you, Madam Chair. And I'm wondering if Representative Jordan, if you'd yield for one quick question.
Representative Jordan, will you yield?
Representative
She
Jordan.
will. Representative Kresha.
Representative Jordan, will you read that quote again? I'm sorry, I couldn't hear the whole thing. I wanted to hear what you said.
Representative Jordan.
Thank you, Madam Speaker. This was a quote from the March 17th Education Finance Committee. We were hearing a Representative Stevenson bill related to class sizes. The quote was, there was a long thing here. It was a longer quote, but the part that I said here was, the fact of the matter is everyone is talking class sizes in these schools. You've all been in your schools as well as I have. It is best that the teachers and collective bargaining units conversations work best in those schools. They know what they are working through the best.
Representative Kresha.
Thank you, and thank you for taking that quote and reading that. And I stand behind it. And members, and Representative Nelson, I've negotiated with you. We worked on many bills. And the reason I think this is important, and the School Board Associations has testified against it as well, is because, as I said in that quote, we don't need to be in those conversations. They're already talking about these. And what we do at the legislative level is we're pushing our thumb on one side of the scale. And these are competent individuals. I do believe in them. I believe in both sides. I've been on both sides in negotiations. I have no issue with the intent of Representative Nelson, what you're doing in the bill, of saying, you're asking that this happen. What I'm saying is it's already happening. We just don't need to put our thumbs on the scale any more than it has to. Let's let the people that we elect locally, that we hire, let's let them do the jobs in the communities we're asking them to do. We have more important, frankly, things to do here at the state legislature. So again, I'd ask for a green vote.
Seeing no further discussion, the clerk will take the roll on the Kresha amendment. The clerk will close the roll. There being 61 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Schultz moves to amend Senate File number 1384. The second engrossment as amended. The amendment is coded A6.
The member from Morrison, Representative Schultz.
Thank you, Madam Speaker and members. And I just want to say, I haven't had the chance to say this yet, and this might be our last labor policy related bill. So I just want to thank Chair Nelson for his leadership on the committee this year, and it's been fun to learn from him, and I've certainly taken a lot from it. But members, this next amendment that I'm bringing here, the A6, is about helping out teachers in that probationary period. And if you're not already aware of what this bill contains as it relates to the probationary period, let me just help paint a picture for you. So for me, I obviously being one of the younger members of the body, I have many of my friends who went to school to be a teacher. And they, frankly, through no fault of their own, have hopped around from one school to the next school as they build their seniority in teaching, which is a good thing. But what we are facing in this bill and the language that's included is a position where the probationary period is actually shrunk, which actually might be disadvantageous to the teachers who go and they're working in a school as they seek to bring about the best teaching skills to their classroom, working with their students. And so I would like, with this amendment, to move us back to what is current state law, which is 120 days for that probationary period. Frankly, because I think it's best for young and aspiring teachers. And so that's my amendment, and I look forward to our discussion. I encourage support.
The member from Hennepin, Representative Jordan.
Thank you, Madam Speaker, and thank you, Representative Schultz. Yes, as Representative Schultz says, this does delete new language regarding probationary periods. This would delete it from 90 to 120 days. And this is already a compromise from the original bill I introduced, which would have reverted us back to the original 60-day probationary period that was in state law. And this compromise came as a result of discussions with organizations representing managers. And this change is necessary for actually just a very few number of educators. And these are educators who are having a major life event, such as delivering a premature baby, a serious illness, or something that happened to a teacher of mine who served in the National Guard and was deployed overseas to serve in Iraq. This would mean that they do not have to repeat a year of probation before achieving tenure. But this is, keep in mind, members, that teachers must still complete 3 years of probation before that goes into effect. And I ask members to vote no.
Further discussion, the member from Olmsted, Representative Quam.
Thank you, Madam Speaker and members. Back earlier this century, I was on the school board, was treasurer, and was involved in teachers that were in probationary periods. I was on the ZED governing board, was treasurer and also presided over that board. And we also had teachers, new teachers. There were occurrences of where, as you get close to the end of the probationary period, we weren't certain. They weren't quite ready. And frankly, it was advantageous, or is advantageous, to have more time in that period. If you want to have some coverage of exceptions, deployment, medical, etc., then write about those and cover those exceptions. I don't want to harm a teacher's chances by having too short of a period of probation for them to prove themselves. And frankly, I much prefer if we'd look at the rare exceptions instead of having the policy of where you've got enough time to make sure, because most teachers, it didn't come up, but there were several, while I was on the board, that we just didn't have confidence in them, at the end of, or near the end of probation. So I see this amendment as advantageous for the teachers in general. And I wish that there was specific language to take care of the understandable situations that were brought up.
The member from Meeker, Representative Erdahl.
Thank you, Madam Speaker and members. Now, we are losing nearly 3 of every 5 new teachers in the first 3 years. New probationary teachers need all the support that they can get to stay on the job. Now, we've made mentoring more consistent over the last few years, and that's important to do. It's an important aid to them. But the observations, critiques, and advice from administrators to new teachers is critical, and this will make that process less timely and more difficult. Now, I was a probationary teacher once. I know how important that it was for me to have the opportunity to explain to administrators what I was doing and for them to offer alternatives. This was an important time in my early career as an educator. We simply must do more to attract and retain teachers. This is a step in doing it. Cutting it from 120 to 90 days is the wrong direction to go. I was privileged a few years ago to meet the architect of the Finnish education system, which is highly regarded in the world, a man named Pasi Sahlberg. I asked him, what makes education so good in Finland? And he said, teachers, teachers, teachers. I asked, well, what about here? He said, train them better, pay them better, prepare them better. More time, more instruction leads to more skill. We don't need less. We need to do whatever we can to make sure that our teachers are better prepared, better in the classroom, and more likely to continue into the profession for as long as possible, which would be like 35 years in my standpoint. But since my cousin's been teaching 60 straight years, I think it's a little bit much to hope to do that. But we need to get our teachers better prepared to teach longer. And this doesn't do that. Thank you.
The member from Freeborn, Representative Bennett.
Thank you, Madam Speaker. I wanted to get some clarity before I spoke because I like to know what I'm addressing here. And I want to say there's parts of this I think I could support with this amendment. When you're going to another school district, having to only do 1 year I think makes sense. But this part about the 120 days versus the 90 days, I think that could actually backfire on teachers. So you think about the beginning of the school year, the toughest time of the year to teach. You have brand new students, more likely to have discipline issues. You're laying out your classroom, and let's say a teacher only has 90 days and they're gone, and they're all at the beginning of the school year. You can look pretty bad sometimes at the beginning of the school year with the types of students, not the types of students, but just that new behavior and setting your classroom structure and all those things. And if we're going to limit this to only 90 days, I think that could actually backfire on teachers, give them a bad report, and then suddenly districts are like, we're not going to take our chance with this teacher. We need to, let this teacher go before we have issues. So I would say in support of teachers that 120 days makes more sense. So thank you.
Further discussion on the A6 Schultz amendment. Representative Schultz.
Thank you, Madam Speaker. And before I get any further, could I request a roll call?
Representative Schultz requests a roll call. Seeing 15 hands, there will be a roll call. Representative Schultz.
Thank you, Madam Speaker, and thank you to the members who've spoken tonight. Many of you know I'm not a teacher, but this is an issue that's been brought to me by my community, and certainly I have many in my family and my friends who are teachers, and especially young teachers and inexperienced teachers. And we do not want our state policy to reflect a position that is going to harm the next generation of teachers. We're having a hard enough time as it is finding good teachers, placing good teachers, especially in a moment today where they can get a job potentially in the private sector that pays much more. So we don't want to be creating a policy that frankly could kick teachers out of teaching sooner than what they may receive if they were coached and worked with. And really, that's the heart of my amendment. And so would the author of this provision, Representative Jordan, would she yield?
She will. Representative Schultz.
Thank you, Madam Speaker. And Representative Jordan, I know that we discussed this in our Labor Committee, but I also wanted to ask you right now, what do you see as an advantage to the change that you're bringing here, especially to an inexperienced teacher who's looking to move beyond their probationary period?
Representative Jordan.
Thank you, Madam Speaker, and thank you, Representative Schultz, for the question. The advantage I see is that if you are having a very difficult time, like you've been diagnosed with cancer and have to have that treatment, that you do not have to repeat one of your 3 years of probation. That's a pretty big deal. And for people who were talking about 35 years ago, I was a probationary period. This probationary period only came into statute in the year 2000, which is less than 35 years ago. Math is sometimes hard for me, so I thought I'd do that addition for folks. And then the other thing is the 120 days only came into effect in the law in 2011. So this is something that has been tinkered with by the legislature, and I have heard directly from these teachers who are probationary teachers and are having a really hard time. Like they had a premature baby and had to spend time in the NICU with that baby and had to repeat then another additional year of probationary teaching before they were able to become a tenured teacher. So that's the advantage I see, is that for those few folks who are trying to be in the classroom and are also struggling or going through something like guard duty and serving abroad, or having a premature baby, or having cancer, that they do not have to repeat an additional year on top of those 3 years.
Representative Schultz.
Thank you, Madam Speaker and members. I don't believe that we heard any testimony to this effect while we were in the Labor Committee specifically stating this sort of thing. And frankly, especially hearing from the colleagues of mine who have been teachers and the members of this body who have been teachers or who are teachers, the case is made that for lesser experienced, inexperienced teachers, that they could be hurt by this policy. And we don't want to put anyone in a position, especially our schools, in a position where instead of coaching and building up great teachers, we're shifting them out of our schools far earlier than we would ever want. So would Representative Jordan yield to another question?
She will yield. Representative Schultz.
Thank you, Madam Speaker. And Representative Jordan, earlier this evening on two separate occasions, but we'll start with the provision specifically related to this amendment. You mentioned that you've been consulting with some folks outside of this body as to this language, and that this was compromise language. Can you share with us who you compromised with to get to the point where we have 90 days?
Representative Jordan.
Thank you, Madam Speaker. Thank you, Representative Schultz. I worked with unions representing educators and organizations representing school management organizations. This isn't language that either of them actually really appreciated, but it's one that I made.
Representative Schultz.
Thank you, Madam Speaker and members. There's a middle ground to find here, and that's what I'm seeking to find tonight, and I want to invite you to join me on it. Because what we've heard so far tonight is that there are plenty of people who are interested in the best quality teachers in our classroom, working and making sure that the next generation, that they're coached appropriately for the classroom and aren't sent to an early decision outside of the school. And so I think that this is important because as I've been bringing these policy issues forward and discussing with other stakeholders, people like the Minnesota School Boards Association, folks who represent school administrators, they weren't consulted on this. They did not provide input, and they also didn't agree to a compromise around 90 days versus 120 days. And this is important for the people at home and especially for inexperienced teachers today. We want to keep you in the classroom. We want to help you become the best and the brightest to teach our youngest learners. And that's why, members, I encourage a green vote on this amendment to return us to our current state law.
Seeing no further discussion, the clerk will take the roll on the A6 amendment. The clerk will close the roll. There being 61 ayes and 69 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Creashaw moves to amend Senate File Number 1384. The second and Grossman as amended. The amendment is coded A7.
Representative Creashaw.
Thank you, Madam Speaker, and members. And Representative Nelson, will you yield for a quick question? Will Representative Nelson yield for a question?
He will yield. Representative Creashaw.
Representative Nelson, so this amendment, I am taking out where the data is from the employer is turned over to the union. And I'm just wondering, as I'm reading through this, and maybe you can answer it, where does it handle in here what they can do with that data and what their provisions are for security of that data.
Representative Nelson.
Madam Chair, or Madam Speaker, and Representative Krisha, I believe that's covered not in the bill itself, but that's covered under our Chapter 13. Because of that, we went to the Judiciary Bill Committee with this language. And what this does is giving the information to the bargaining unit, to the exclusive bargaining rights, is that whether they join the union or not, if they have an issue, the union has to represent them. If they don't have this information of who these people are or where they are, and sometimes they may work at part-time at one school and part-time at another school, but because they need this information, because if, say, one of these individuals has a problem and they want to file a ULP against their school, they need this information so that the person, that the employer or the exclusive bargaining unit can track them and get a hold of them and deal with these things with them. So that's what information is about.
Representative Krisha.
Thank you, Madam Speaker. And if Representative Nelson, if you'd yield for one more thing. But they can voluntarily opt out of it, right? The employees, the new ones, they don't have to give that information. There is an opt-out. That's correct, right?
Representative Nelson.
I do not believe there's an opt-out, and I'm Representative Jordan shaking her head over there. There's not an opt-out, and the reason being is the union needs to know who these people are, because if they're the bargaining representative, and this person, they can opt out of joining the union, but if they have a problem, the union is required, even though they're not paying fair share dues, the union is required to represent them, and represent them if they have problems, and represent them in issues they have on the job site. The union is forced to do that. Janus aside, by federal law, they're required to do that. That's why they need this information, so they know who these people are.
Representative Krisha.
Thank you, Madam Speaker, and thank you, Representative Nelson. So, members, there's no opt-out. So you get hired or not choose to get in the union, you don't have a choice. They get your information. This body has dealt with data privacy issues how many times? I mean, is nothing sacred anymore? Is your own data no longer protected that we just callously say, nope, you can't opt out? Why? Because they need it. They need it for what? If you have a sick kid, the union is going to try to get a hold of your spouse or your partner to try to deal. No, they don't need it. You can give that to them voluntarily. That's your data. I don't understand. I mean, honestly, for all the things in the bill, I can't understand why we would take it to this level where we're going to pass through data privacy and personal security practices. And sure, I'm sure in another chapter we handle this, but every day we read of cybersecurity breaches. Every day we read of data that's being lost through transactions. So you're going to trust your data that you didn't want to give in the first place to an administrative assistant who may not know how to password protect an Excel document. And by the way, it doesn't have to be an Excel. It could simply be a note document, because if you read in here, it says an Excel or any format agreed upon. So if I pull up Notepad on my iPad, copy and paste, zip that over, there you go. Really? Think about that one. Take the politics out of her for a second. Forget that I'm a right-wing nut job hack, and think about this for a second, folks. We are not allowing people to opt out of giving their personal data, even if they choose not to join that bargaining unit. Why? Because they need it. Members, that seems even beyond the scope of the craziness we've done here. So I would ask for a roll call, and I would ask for a green vote.
Representative Krisha requests a roll call. Seeing 15 hands, there will be a roll call. Discussion to the A7 Krisha amendment. Representative Jordan.
Thank you, Madam Chair, and thank you, members. I would point to Section 1, Subdivision 6, that does detail the duties of the union that the data will be used for. I will read it. It is to conduct elections, which is already in current statute, and then we added investigate and process grievances. And it also says in the bill that liability is with the entity that the data breach occurred. So if the data breach occurred with the union is liable for actions resulting from that. If the data breach occurs at the districts, which we have seen in districts across this state, then the district is liable for data breaches as it refers to that. But I will remind members that not all workers have to join the union under Janus, but unions have to represent all of the workers that are in that bargaining unit, whether or not they pay union dues. So it's very important that unions do get this data. I heard from one individual that was fired from their job, and their union representative found out that that was an unfair labor practice and they did not need to be fired. But there was no way for the union to contact that employee because they didn't have their email address or phone number. And so making sure that unions have that data on the offset is critical so that they can do their job that they must do to represent all of the workers. So I ask members to vote no on the A7 amendment.
Discussion to the A7 amendment. The member from Scott, Representative Bakeberg.
Thank you, Madam Speaker. Thank you, members. Representative Krisha, thank you for this amendment. I just want to recenter our conversation back to just some common sense and how things actually work in a building. So just as a reminder, each building that I've ever worked in has something called a building steward. That's the contact person for the union. And that is the go-to person within the building if there is a union issue that is happening. So that's the first thing that I think is important to keep in mind. But also, we're talking about schools. So let's really focus on what's important, and that's the kids in the schools. And if we're going to be honest, we don't always spend the time talking about kids and how kids are impacted by decisions. Also, I'm hearing a lot of concerning conversations about administrators, about school boards, about just communities, and really a lack of trust for our school districts. That's concerning, members. Our school districts, right now, they are very concerned about what's going to happen. I was at school this morning and had a meeting with my superintendent and my business manager. They are concerned. They're concerned about the debate we're going to have tomorrow night and what that means. There are a number of issues with this underlying bill, specifically the provision about personal data. And I want to repeat, that's personal data. It's not my school district email. It's not my school district cell phone number. It's not my school district office phone. That's my personal email. I was a member. When I taught, I was a member of Education Minnesota. I was a contract negotiator. I negotiate our contracts for our principals group. We have to be honest when we're talking about personal data. I hear often from teachers who are members of Education Minnesota that they don't trust what is happening with Education Minnesota. Not the local, but Education Minnesota as a whole. They are very concerned that Education Minnesota is more concerned about what happens within the 494, 694 loop than what happens outside of that loop. That teachers outside of the metro is what I will often hear from teachers. Not my words, folks, teachers. That we aren't concerned about. Then they don't care about us. They don't care about our voice. There are a number of teachers, and I hope that you listen to this, because we talk a lot about people being bullied. We talk a lot about people being harassed. I have had a number of teachers tell me, Ben, I don't want my personal data shared because I felt bullied or harassed, that I have to join the union. There's a lot of benefits to the union. I was a member. but no one should ever feel bullied or harassed to be part of a union. And when we are giving out personal data without consent, that is illogical. What we should be focused on are the kids in the building and how do we create an amazing learning environment. And I agree that a student's learning environment is the teacher's working environment. But I would also say it's every educator in the building, not just the teachers. It's the paras, the cooks, the custodians, the bus drivers, and even the evil administrators. But we should be talking about how do we fund our schools? How do we appropriately fund our schools and fairly do that? And then all of us who have no business telling a school how to run their school, we have no business doing that. Let's get out of their way, let's fund them, and let them run their district. Thank you for the amendment. Vote green.
The member from Anoka, Representative Scott.
Thank you, Madam Speaker. Would Representative Jordan yield to a question?
She will yield. Representative Scott.
Thank you. Representative Jordan, I know we heard this bill in Judiciary and Civil Law, and I had issues with it there, and I still have issues with it here. And I want to thank Representative Bakeberg for his comments because he deals with teachers every day. I have two good friends that are teachers, and I was telling them about this, and they said, no, they're not getting my data. So what I want to know is, how does this work? Does the union, are they going to be getting the data from the administration, or are they going to compel the new employee to hand it over?
Representative Jordan.
Thank you, Madam Chair. And if you give me 1 second, Representative Scott, I can find the part of the bill, the line where it details how the data will be disseminated to the bargaining units. And this was also covered as part of the amendment that I had as well. And so within 10 calendar days, and we changed it to 30 calendar days with my amendment, the public employee must provide the contact to the exclusive representative or the union in an Excel file format or other file format agreed by both parties with the data. And then there is also another Excel file or similar format agreed to by both parties every 120 days beginning on January 1st. And so it isn't an Excel file data, or it isn't an Excel file or format agreed to by both parties.
Representative Scott.
Thank you, Madam Speaker. So, Representative Jordan, if she would yield to another question?
She will yield. Representative Scott.
So just to clarify, Representative Jordan, the bargaining units, the union is asking the administrators who have this private information to turn it over, or are they asking the individual teacher?
Representative Jordan.
Thank you, Madam Speaker. Thank you, Representative Scott. And let me correct myself. It's actually 20 days, not 30 days in my amendment. It would be from the school administrator or the city or other unit of government that is providing the data, not the individual itself.
Representative Scott.
Thank you, Madam Speaker. Well, so what we have here, folks, is they're compelling the administration to turn over private information, private contact information of teachers to a third party, which is the union. And what happens, again, if there's a data breach with the union? Are they held responsible? Can the employee sue the union? If Representative Jordan would yield again.
She will yield. Representative Jordan.
Thank you, Madam Chair. Yes, the union would be liable for the data breach.
Representative Scott.
Thank you, Madam Speaker. Well, while that's fine, I don't think that's going to give a lot of folks a lot of comfort. People don't give over the private information for very, very good reasons. One of which is who wants to give their private information away to any, whatever entity so that they know because they know that person is going to contact them, harass them. And this is not what government should be doing. We should not be voting on something like this to allow a union to do that, to compel these administrators. Would Representative Jordan yield to one more question?
She will yield. Representative Scott.
Thank you. Representative Jordan, what happens if the administration says, no, we're not going to hand over that information?
Representative Jordan.
Thank you, Madam Chair. Thank you, Representative Scott. Excuse me, Madam Speaker. Then they would be in violation of this law should it pass.
Representative Scott.
Thank you, Madam Speaker. Would Representative Jordan yield to another question?
She will. Representative Scott.
Thank you. And what would the consequences be to that?
Representative Jordan.
Thank you, Madam Speaker. Thank you, Representative Scott. The consequences are not outlined within this bill, but that would probably be an unfair labor practice or a ULP.
Representative Scott.
Thank you, Madam Speaker. If Representative Jordan would yield to another question.
She will. Representative Scott.
Thank you. I don't know what that means. So what are the consequences for an unfair labor practice, that, whatever it was that you just said? What are the consequences for that, a violation of that?
Representative Jordan.
Thank you, Madam Speaker. Thank you, Representative Scott. Generally, and I actually think that Representative Nelson might be able to better detail this than I would be. But generally, when I've had this happen when I was a union organizer, this meant that BMS would intervene and go through with it. And there are other parts of statute that outline what a ULP is through BMS.
Representative Scott.
Thank you, Madam Speaker. Well, I'm really still not finding out like what the consequences to an administration would be. Would Representative Bakeberg yield to a question?
He will yield. Representative Scott.
Thank you, Madam Speaker. Representative Bakeberg, so in your experience as a principal, if you're following this conversation, what do you believe the consequences would be if you chose as a principal or the administration chose as a principal not to share this personal information with the union?
Representative Bakeberg.
I would probably have a conversation with my superintendent. But, you know, I think Representative Jordan outlined it. It would lead to further conversations with the union, depending on which bargaining group it is. I think it's important to understand that most administrators have really good relationships with their bargaining groups, with their building stewards. So I would hope that it would never get to a point where we would be forced to do something like this. But many administrators, every administrator that I know, makes it a point to build that relationship, build that positive relationship with the building stewards so it wouldn't come to that adversarial piece. And then if it does get to a point where we have a difference of agreement, there's a process in place called meet and confer. So then it would move to that meet and confer item, and then we would have a conversation there. And then it would ultimately end up, if it wasn't resolved at a meet and confer level, it would go to a school board. So thank you.
Representative Scott.
Thank you for that answer, Representative Bakeberg. Members, none of us would be okay, most likely, handing over our information like this, especially when we can't say no or give consent in this situation. This is a really, really bad road to go down. It's not necessarily, why doesn't the union just have an organizing event and invite people through the school email, and if they want to turn over their contact information at that event, they could do so without having to take it from someone against their will. Please vote for this amendment, members. This is nonsense.
Any further discussion? Representative McDonald.
Madam Speaker, thank you. I rise to support the A7 amendment. Just some food for thought. We all get these green books. Our names are in here, our pictures. Some of you guys have aged quite a bit. You probably need a new picture. I'd be happy to help with that in the future. But in here, it lists our address or email address. What email address are you asking, Madam Speaker? Your house email address. I looked through this. I don't think any one of you wisely shared your home personal email address. Madam Speaker, I also looked through here. Most of you were smart enough, unlike yours truly, not to put your cell phone in this book. I meant to cancel that 6 years ago. Doggone it. But you would never put your personal information there. Hardly any of you have your address in there. You have the city, because it's good to have our constituents know where we come from. Wouldn't you agree? But certainly not our street address. not the time or the hours we're at home, or the times we have dinner or watch The Price is Right. And it certainly doesn't have your cell number or your personal email. Now, I think you all would agree that's probably a good idea because there's some wackadoodles out in the world that just love to take our personal information and contact us in not such a nice way. If they want to do that, they can call us here at the Capitol, the SOB, or email us, and I'm sure you know you receive all kinds of crazy and good things too. So the A7 amendment certainly would take out that provision, Representative Jordan, that has no business whatsoever forcing a teacher to hand over their personal information. Madam Speaker, can you imagine if we were forced? Matter of fact, if we had not a 24-hour rule, I'd adopt an amendment to force us to have our information in there. I bet everybody would vote against that. So this is a very personal amendment to those teachers that are forced to give their personal information in the ether. Really, if you don't think that your personal information should be in this green book, and it's not, then vote for Representative Krisha's A7 amendment and do the right thing.
The member from Carver, Representative Nash.
Thanks, Madam Speaker. Would Representative Jordan yield to a question briefly?
She will yield. Representative Nash.
Thank you, Madam Speaker. And Representative Jordan, I have always been a big supporter of the Secretary of State's Safe at Home program. And my fear, and this doesn't necessarily directly apply, but there are teachers that are likely to be folks who have survived domestic assault and violence. And if you publish their home address in a file that is as porous as an Excel or a CSV or a Word or a Notepad or any of that, and it goes to a union and that gets breached, and I got to tell you, working in cybersecurity for the time that I have, I know hackers that can hack almost anything just like that. And I fear that by requiring that this data gets handed over, that this is effectively going to give folks, either former partners or domestic partners, or even students who are they have a grudge with their teacher, that you've now given them a roadmap to go and create a very tense situation at their home. And I also notice, as a second question, you've not put any requirements for data handling in here from a security perspective, and I don't see any best practices. So the first one is domestic violence and stalkers. That doesn't seem to be addressed at all, that you're just handing that data over. Could you please address that?
Representative Jordan.
Thank you, Madam Chair, or Madam Speaker. Thank you, Representative Nash. Safe at home data is kept private and it would not be disseminated as part of this. And then I would need you to repeat the second question.
Representative Nash.
Thank you, Madam Speaker. We both talk very quickly sometimes, I know. So my fear is this: you're handing over to an outside organization, and it could be a union or anybody for that matter, without any requirements on how to safely handle that data from a cybersecurity perspective, or because there's no best practices that you've outlined in here. I think that that's a big problem. But the bigger problem is that yes, Safe at Home is not here, but not everybody enrolls in that. So there are likely to be victims of sexual assault in the past that are going to have their name out there, and it's very easily cracked. So help me understand why you did not put any data handling provisions or cybersecurity requirements in this.
Representative Jordan.
Thank you, Madam Speaker. Thank you, Representative Nash. To be very clear, this isn't data that is being published. The data can be disseminated only to the extent that is necessary to conduct elections and investigate and process grievances and implement the provisions of chapters 179 and 179A. And then also to Representative Scott's question, that the portions that are actually earlier about the extent and the process of if there's a dispute, is it would go to Bureau of Mediation Services. They would look at the data and then ask the district to turn it over. There is other parts of statute, and I'm sure Representative Nash, you know those parts of statute better than I do, about safe data handling that would be applicable.
Representative Nash.
Very quickly, Madam Speaker. Well, Representative Jordan, on line 12.23 and 12.24, there is personal information there. It's their address that is now potentially going to be handed over to the union prescriptively. And again, it is super easy to hack anybody. So you've seen schools in the news that have been hacked. And again, I work with a bunch of people who we go to competitions as white white hat hackers, and we win all the time. It is not difficult to take down a school. It is not difficult to take down a union. It is very easy to infiltrate their systems. So just by passing them this data that, as Representative Krisha said, they don't need, you are putting a good number of people at personal risk for stalkers or other sexual assault folks. So I would urge the adoption of the Krisha Amendment, the A7. Vote green.
Discussion. The member from Olmsted, Representative Quam.
Thank you, Madam Speaker. I was going to touch on the same as Representative Nash because I know and knew teachers and school staff that didn't have their addresses. We didn't have it openly available in our district because they had situations. And frankly, there are a lot of issues about if you're going to force a district to give information it doesn't have because that person's information is protected because of good reason, and the fear that these people, if you've talked with someone that's had this issue, the fear that their information will get out, that they're constantly worried about, and not having an opt-out, I think is problematic legally, and I think it's problematically, I personally have a lot of issues without an opt-out because, frankly, if you've talked with some of these people and what they've been through, you would have an opt-out.
Further discussion on the A7 amendment. Representative Nelson.
Thank you, Madam Speaker and members. Having served as a business manager, financial secretary for my local union, and a little history about unions. They're very, Representative Scott would be impressed by how tightly they hold their information that they receive on their members. Going back in history, if the name of someone that was in the union got out, they were blackballed from jobs, they were harassed, they were all sorts of terrible things that used to happen, and some of that stuff still happens today. Unions are very, very tight with who are their members, and they don't share that information with anybody. But they need this information because they're required by law, it's called the duty of fair representation, that if somebody that's working where they are the exclusive bargaining unit, they have the duty by federal law to represent those people. And if they don't have the information of these people that are working there, and again, with Janus, they don't have to pay dues, they don't have to pay fair share dues, they are still required by law to represent these people. And if they don't have those names and addresses, they're not able to do that. And they could then be sued by somebody because you didn't represent me when I had a problem. So members, that's what this information is about. That's what this part of Pell we're upgrading. And it's not just schools, it's your cities, your counties, I don't think most townships would have union representation, but it's places like that that have those representation, and those people are required to give this information. It's not just schools.
Further discussion. Representative Krisha.
Thank you, Madam Speaker. And by the way, bless you. Allergy season.
I almost called on Representative Kennedy over there. Representative Krisha.
Representative Nelson, thank you for all that. A couple things you said there. I have no doubt that union representatives and unions run a tight ship and keep clamps on the data. Then don't require it because you'll build the trust. We're talking through all the iterations of what could happen. You know how we solve that? Allow them to voluntarily give the data. Because once they voluntarily give the data, then we remove all of that. We remove all that doubt. So I was thinking about a couple things, as you said, and someone said, well, it was hard to contact them. Maybe they didn't want to be contacted. There are times that I don't give people information because guess what? I don't want you to call me. Another thing is I heard they need the data to negotiate. Okay, so I've been in negotiations. You're going to tell me that they're sitting in a room and they're just about to close the deal and someone says, hey, they pick it up, email fuzzyslippers07@gmail so we can close this thing up. Or email I love Monty Python 99@gmail so I can finish this deal. Really? They need that data. No, they don't. No, they don't, members. And I know I'm being a little bit facetious, but I do bring this up. The greatest breach of the data is not the union representative or the people that are maintaining the data. It's when you're in that room and someone says, hey, email this person, and they say it out loud or they write it on a Post-it note that gets left on a desk. That's where the breach of data occurs, members. That's where it's because of lax practices. That the person who didn't want you to have the personal data anyway had no control over their name being on a sticky note that was left on a desk and everybody picked up all their papers and left and your stuff was there. And if you're in a small town like mine and those names get out on lists, guess what happens, folks? People start emailing lists and they start sending things, we've all gotten them. You start getting things on your list that you didn't wish to get. And it can come from either side. I have a district right now that is dealing with people that have access to names and lists. They don't know how they got on there, but they're getting material they don't want. This is how it starts, members. So I would just say this, members, just give me one green vote on that side. Just give me one person over there who says, you know what? I can see where somebody just doesn't want to willingly give their personal data. Just give me one green vote. Show me somebody over there who respects the fact that this can be an opt-in and doesn't have to be mandated. So, members, I would ask for a green vote on my amendment.
The member for Santee, Representative Dowd.
Thank you, Madam Speaker. I didn't realize we were wrapping up, and it was rude of me to stand up after. But you know what? This is what's going to happen. You ever fall for that free vacation deal where they do the timeshare presentation? That's what they're going to use this information for, is the timeshare presentation. They're going to make all the employees sit through it and try to sell them on the benefits of being in the union. I don't like those vacations, and we shouldn't subject people to those timeshare presentations by the unions. If they want to, they can be voluntary, and people can go and join the union if they want to, just like they're guaranteed right now that right under federal law that if they don't want to, they don't have to. But we certainly don't need to subject them to the timeshare presentation, and that's what this will do. So thank you for bringing the amendment to get rid of it.
The clerk will take the roll on the amendment. The clerk will close the roll. There being 61 ayes and 69 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Carisha moves to amend Senate File Number 1384, the second engrossment as amended. The amendment is coded A8.
Representative Carisha to the A8 amendment.
Thank you, Madam Speaker, and let's just get the roll call out of the way.
Representative Carisha requests a roll call. Seeing 15 hands, there will be a roll call. Representative Carisha.
Thank you, Madam Speaker. And members, okay, so I lost on the other two amendments. And then I've been looking at this amendment since I drafted it. And at first I thought, you know, I really want to go after this language. But now I think I kind of like that we should keep the language even though I'm going to ask for you to take it out. And here's my reasoning, because what Representative Dowd just said, and I was thinking this through this. So now they have your data, the Janus decision's out there, and what my amendment does is it deletes the section that says you are required to meet with the union representative for 30 minutes. Members, this is the Zig Ziglar amendment. This is the timeshare. This is, hey, let's build our membership up by talking about the great things. And oh, by the way, would you like some steak knives? Because I've got your data here. And how about a timeshare in Florida? And then now that I can sell my list, I can go on and on and on. So really what we're doing is we're upselling, which I love. In my company, all my employees know we upsell. You ask the next question. So, hey, how's your union representative? And oh, by the way, can I interest you in this? Can I interest you in this? Members, really? We're going to require you to give your data. You don't get to opt on that. And now I'm going to require you to sit down for 30 minutes with a union representative while you get the spiel. Think about that. We're going to require you to go through the union upsell. So, sure, why not? You have the data, you have the list, you can check it off. In my world, we don't call that a demographic list, we call it a lead list, and we don't have to do cold calling anymore because guess what we got? So members, vote green and try to take Zig Ziglar out of our union process.
Rough night for timeshares on the House floor tonight. Representative Jordan.
Thank you, Madam Speaker, and thank you, Representative Krisha. To be very clear, that employees do not have to meet with union representation. That is not what this bill says at all, and that's not what your amendment would do, is take away that, because that's not in the bill. And in fact, there actually is a really great provision from Representative Berg about captive audience meetings and would prohibit those in the workplaces so that employers wouldn't be able to force their employees to go to a non-work related meeting. And so if you're really into that, you should be sure to vote for this bill because Representative Berg has done some great work on this. But this amendment is another one. It's very similar to the last amendment, as Representative Krisha said, and I would encourage members to vote no. As we've talked about extensively, unions have to represent all of the workers, whether or not they are in the bargaining unit and pay dues. And they need to be able to inform employees of their rights and their contract duties and be able to negotiate for them on their behalf. And I ask members to vote no.
Further discussion on the A8 amendment. The clerk will take the roll on the A8 amendment. The clerk will close the roll. There being 61 ayes and 69 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Schultz moves to amend Senate File Number 1384. The second and Grossman as amended. The amendment is coded A5.
Representative Schultz to the A5 amendment.
Thank you, Madam Speaker. The A5 amendment is mine, and this is an amendment to speak a lot to who really has the authority in a lot of these discussions, and especially resulting in kind of the weight and the understanding and the provisions to understand exactly, at the end of the day, who has the fiduciary responsibility as it relates to management responsibilities around our schools. And so that's my amendment. And so this strips two provisions from the current bill. It strips out Section 12 and Section 15, and I encourage support of this amendment.
Discussion to the Schultz amendment. Representative Jordan.
Thank you, Madam Speaker, and thank you, Representative Schultz. Yeah, this takes away the voice of workers to have a voice in their staffing ratios. This is something that our workers are asking for. It's commonly cited by people who are leaving our workforce and leaving the teaching profession and leaving other areas of public service, that they do not have this voice in the job and they are asking for it. I would also say that educators have a very strong interest in keeping schools financially solvent. They're employed by the districts after all. School closures would impact them as well. And there is another thing I want members to remember, is that there is nothing guaranteed by this bill. There are no staffing ratios that are guaranteed. This just makes sure that there is a conversation that happens. And so I ask members to vote no on the Schultz amendment.
Further discussion, the member from Scott, Representative Bakeberg.
Thank you, Representative Schultz. Thank you, members. Thank you, Madam Speaker. Just the ability to bargain. I've heard that over and over again tonight. I've heard that online. That's all this is about, is just the ability to bargain. The simple fact is every single bargaining group already has that ability to do that. When I was a contract negotiator for our local, we decided what was our priority, what were our priorities, and we brought them forward. Minneapolis, the Minneapolis Federation of Teachers struck last year over this. So it's already there. We already have the ability to do this. I had a very good conversation with some of the advocates on this, and they just said, Representative Bakeberg, some people just really want to talk about it. Well, just because some people want to talk about it doesn't mean that it should be mandated from here. If the local bargaining group wants to negotiate that, they can. But I really want to just address some of the conversation we've had in this chamber. I heard a member say that teachers want to have a voice in their job. And I'm certainly not impugning motives. But the other side of that is that administrators don't hear their staff, that don't value their staff. The unintended message that is sent is that school boards don't know their staff, don't respect their staff, and nothing could be further from the truth. Our locally elected school boards, quite honestly, I think their job is a lot harder than our job. Because when they go to the grocery store and they just cut teachers because we didn't fund them, we're not hearing about it, but they are. When they cut an activities program, a fine arts program, a music program, we're not getting phone calls. They are. When they have to implement divisive curriculum that we force on them, we're not getting phone calls. They are. They get them at the grocery store. They get them when they go to their kids' game. They get them at church. I know this because I've seen it. And when we in this chamber put mandates on our schools and we disrespect our educational leaders, that's unacceptable. Provisions like this tie the hands of school boards to make decisions that are best for their local level. They are the locally elected officials in their communities. Let's trust them. It ties their hands for future negotiations. They will not have the funds to give contract settlements for years to come. We have heard all through the campaign season, schools are going to get historic money. That's the perception within our communities. But provisions like this and other ones, and I know Chair Joachim is working really hard in conference committee, but there's a lot of concerns about what's going to come out. But the parents that are working hard, providing for their families, they're not aware of all of the moving pieces. All they hear is schools are getting historic money. And there's a real chance that schools will go backwards. We need to provide funding and flexibility. That's it. And let's get out of the way and let the schools do what they do best. Let the local districts do what they do best, determine what's best, and innovate for their local districts. Vote green.
Further discussion on the A5 amendment. Seeing none, the Representative Schultz.
Thank you, Madam Speaker, and I would request a roll call on this
Representative Schultz requests a roll call. Seeing 15 hands, there will be a roll call. Representative Schultz.
Thank you, Madam Speaker. Members, I bring this with a very specific purpose in mind, and Representative Bakeberg did a fantastic job outlining this. My constituents, the school board members, and the school administrators in my district reached out to me ahead of time, prior to me even offering this amendment, concerned with this provision. Provisions that, some of these provisions are included in multiple bills this session. They're concerned about the mandates. They're concerned about the heavy hand that's going to be at their school district. And I mean it so sincerely when they're going to be cutting programming for the students in my community. And I put it through the lens of my own community, but I'm sure that's the same in other communities like Circle Pines or like Stillwater or places like Virginia or others. These communities and our schools are going to have less programming if we go this route, because this provision that's currently in here gives that managerial authority to the employees, right? Not the school board members, locally elected in their community. I brought a couple of my school board members to the House this year, and they're concerned with this provision. And so this is about providing for local control, local elected control, so that we're not at a place where I'm getting emails and contacts from the superintendents of the largest school district in my district that say that they're going to have an additional cost that's going to result in the cuts of 6 different teachers. That's what this does. 6 different teachers who won't be in the classroom teaching our kids. That's the impact to making this sort of change, these additional mandates that make it challenging for the people elected to do the job to do the job. So if we want to have more teachers in the classroom, if we want to have smaller class sizes, the way to do it is not through the policy contained in this bill. So vote green on this amendment so we can get back on track. Thank you.
Further discussion on the A5 amendment? Seeing none, the clerk will take the roll on the A5 amendment. The clerk will close the roll. There being 61 ayes and 69 nays, the motion does not prevail. The amendment is not adopted. There is one more amendment at the desk. The clerk will report the amendment.
McDonald moves to amend Senate File Number 1384. The second and Grossman as amended. The amendment is coded A9.
The member from Wright, Representative McDonald.
Madam Speaker, the last amendment, well, I'll be quite quick. I'll attempt to anyway. The A7 amendment goes to repeal, or actually to remove Section 22, which is the employer-sponsored meetings or communications, also known as the gag law or the captive audience. So if you believe in freedom of speech, then vote for my amendment. If you believe in that the employer and the employee should be able to collaborate and have free debate and free discussion, then vote for my amendment. If you believe that there should be free and open communications between the workers and the boss, the employer, and allow them to work together collaboratively, congeniently, in good communications, then vote for my amendment. And if you, the A9, is that what it is? Good. And if you believe that the Supreme Court for almost 80 years has upheld the right of employers to speak with their employees about unionization and found that Congress specifically intended and encouraged the free debate on issues that divide labor and management, then you should vote for this amendment. This amendment, of course, in committee, we had no one indicate whatsoever that it was happening in the first place. Now, the first part of the bill, if you read it, it does make some sense. No employee should be fired for not attending one of these meetings. First of all, it's not happening at all. And the bill is so vague that it would potentially, Madam Speaker, disallow an employer to talk to its employees about important issues. about union issues or labor issues. Or let's say you take a school, a religious institution, who wants to talk about important religious issues that pertain to that school. And it would disallow that from happening and or discourage it. Furthermore, if any employee thought that they were coerced or felt forced to go to the meeting, they would have an ability to retaliate against the employer, and then therefore causing more litigation, because the Supreme Court had already ruled, as I said, for over nearly 80 years, that they have the right, the employer and the employee has the full right to have an open and free communication. So I ask you to support this bill. And let me just furthermore read on the second page of the bill, if I can find it here. I'm sure some of you that are very active in your communities, the Lions Club, nonprofit groups, civic groups that are in your community that do so good, many of those groups are organic and happen within employers, in businesses. I know that's the case in my county, Wright County, and in Delano. But this particular bill would discourage that any employer would communicate or even ask their employees to come to a meeting that talked about political things, political party, civic, community, fraternal, or labor organizations. And that just is not right, and it's certainly will take away the freedom of speech and open it up to potential, Madam Speaker, litigation, because I said, as you heard earlier, the Supreme Court already ruled in this. And there may be a gentleman on our side that has a law degree that wants to mention that as well. So that's the amendment. I encourage a green vote. Thank you, Madam Speaker.
Discussion. The member from Dakota, Representative Berg.
Thank you, Madam Speaker, and thank you, Representative McDonald, for your amendment. We spent a lot of time in committee talking about this. So essentially, everything Representative McDonald said is wrong, even though it was said in the best of ways. So what this bill does do is it protects employees' freedom of conscience by prohibiting employers from forcing employees to attend meetings or listen to speech on religious or political matters, including captive audience meetings intended to convey the employer's opinion about unions. It prohibits employers from retaliating against workers who decline to participate in the religious or political communications that are unrelated to their job duties. It allows aggrieved employees to bring a civil action in district court. What it does not do is it does not prohibit employers from discussing workplace issues. It does not prohibit employers from asking or inviting employees to religious or political meetings or to communicate about religious or political matters, as long as employee participation is wholly voluntary. It does not prohibit an employer from communicating information to employees that is necessary for the employees to perform their job. So that basically speaks to everything that Representative McDonald spoke of in his speech about his amendment, but I want to make sure that we talk about one specific thing that is really important in the discussion and comes up a lot. So we talk about religious employers, for example, like Catholic schools. They are exempt from laws that prohibit discrimination based on religion. Under the Minnesota Human Rights Act, a Catholic school can insist on hiring only teachers who are Catholic, and therefore requiring them to attend weekly mass with the student body. And this is statute 363A.20. So there are actually exemptions for religious schools. And this does not infringe upon freedom of speech. It just says that the employee has to agree. It has to be voluntary if you're going to have these kind of meetings that talk about political or religious subjects. This is one of the top union busting tactics that is used, and this prohibits that. Thank you, Madam Speaker.
Further discussion to the McDonald amendment. They did mention a case, didn't they? The member from Anoka, Representative Niska.
Thank you, Madam Speaker and members. Thank you, Representative McDonald. I was thinking about not standing up just to see if how that would work out for you. But members, I do have a couple of concerns about this bill, similar to Representative McDonald. First is that it has very sweeping and vague language, unlike what Representative Berg just characterized. If you read the bill and think about a bunch of different situations, it's really unclear how this is going to work in practice. And second, this is clearly a regulation of speech, and there are areas where we are essentially censoring speech that are black and white censorship of speech, but there are whole swaths of speech that's sort of in the vague gray area of the sweeping language of this bill that results in people being chilled from speaking in ways that might be legal or might be illegal under the law, but is certainly unconstitutional for us to be chilling protected speech. But the vague language in this bill that's particularly problematic, some of it, is that there are situations in which employers have to have mandatory meetings, or even if there is a meeting that might not be mandatory, but the employee has a good faith reason to think the meeting is mandatory. There's a good faith complaint provision or good faith report provision in this, where an employer just happens to mention something that's within these sweeping categories of political and religious matter. And especially if you read the way political matters are defined, it could result in pretty significant legal implications of the bill. So there are required meetings that every employer has that might potentially accidentally trip up an employer. And I'd like to explore some of those examples with Representative Berg if she will yield.
She will yield. Representative Niska.
Thank you, Madam Speaker. And Representative Berg, if you'll just indulge me for a little bit, we all, as members actually even of this House, had mandatory harassment training. And many employers have mandatory training that is meant to make sure that all the employees understand their obligations to keep the workplace safe. And sometimes, it was my experience here that I actually had to fill out something that said that I had gone to that training. If in the course of one of those trainings, in particular as it related to religious sensitivity and religious training, the employer stood next to the trainer and said, introduced this and said, "This is very important to me because I am a person of faith. In fact, I'm a person of the Christian faith. And it's very important to my faith that everyone treats everyone's faith or those of no faith with respect. And therefore, and as a result, now I'm going to turn it over to this trainer to tell you about your obligations to prevent religious harassment." At that point, if I'm reading your bill correctly, they have, in that mandatory meeting, expressed the opinion of the employer on a religious matter, and now that meeting is implicated under the new legal requirements under this bill. Can you help put to rest that concern that employer has now run afoul of Minnesota law?
Representative Berg.
Thank you, Madam Speaker. Before I answer what I assume will be your multiple questions, I just want to point out, as the founder and currently only member of the I'm Not a Lawyer caucus, I'm going to try the best I can. So if you're standing, if you're attending an employer-mandated harassment training, I would hope that they didn't stand up and say, "This is very important to my faith," because that can be considered harassment. However, if they do say, "It's really important to my faith that we treat everybody with kindness," and that's all the further they go, that's probably going to be okay. But if they go on to say, "And this is why everybody here in this room should join my faith, and we meet at 10 a.m. on Sunday," right? Like, it has to go further. You have to basically be recruiting people into your faith. I wouldn't consider it very smart to bring your faith into the discussion, but as long as it doesn't go on and on and on, and employees that do find that offensive or do think it infringes, they are welcome to leave, and they cannot be retaliated against for it.
Representative Niska.
Thank you, Madam Speaker and members. I think what we heard there is that there's some line, some invisible, indiscernible line, maybe relating to recruitment, a word that's not in the bill, that an employer in this situation where they do have a mandatory meeting or even a meeting where employees feel like it's mandatory, where there are certain words that they can say and certain words that they can't say. And maybe they know what that line is. Maybe they have to go consult a lawyer about what that line is. But that is the very definition of chilling legitimate speech and trampling on First Amendment rights. And I do feel like a broken record sometimes in this chamber, talking about all of the different ways that the majority is trampling on constitutional rights. But this one is pretty black and white. The government is picking and choosing certain speakers. Only employers are targeted, individual employees are not, unions are not, and the government is picking and choosing certain content that is allowed, quote, political matters or, quote, religious matters. And what's worse, that is core First Amendment speech. The Supreme Court has ruled over and over again that political speech is the core of the right to First Amendment, and obviously religious speech is as well. It's actually mentioned specifically in the First Amendment. The vague and curious wording of the definitions, like political speech, includes the decision to join or support, quote, a civic or, quote, a community organization. I don't know if that means inviting people to recruiting people to a Lions Club fundraiser or recruiting people to be members of the YMCA. Perhaps that's also covered speech. I sure hope not. But again, we're talking about vague, sweeping prohibitions on speech that are either going to be a black and white violation of the First Amendment, or at the best, censoring some speech and chilling other legitimate speech. No matter how this plays out, it's not clear how it plays out in the context of an employer who has a mission within the meaning of political or religious matter, like political campaigns, public policy organizations, religious organizations or associations, or the same kind of civic, community, fraternal labor organizations like the YMCA. How does this apply in the situation of the YMCA or the Lions Club? And Representative Berg, thank you for pointing out that in other statutes, we actually have figured out how to write clear exemptions for particular types of religious organizations. It would have been a good idea to maybe model the Human Rights Act in the way that the Human Rights Act does specifically carve out Catholic schools and things like that, and written a carve out into this bill. That didn't happen, and as a result, this bill should not be passed at this time. You know, sometimes I think that this session is kind of like the Constitution or the Olympics of unconstitutional bills. And if that's the idea, if that's been the purpose of the last couple of months, then I think it's fair to say this bill is a good contender for the gold medal. It's flat out censoring what can and cannot be said in mandatory meetings, and even where the speech isn't banned, it's chilling speech where the employee might have a good faith report of a suspected violation. That's language directly from 1514. We were talking about timeshares. This is more like the infomercial. But wait, there's more. In this same bill, where we are silencing some speakers on some topics, we are requiring them to provide another speaker with information on those topics and to allow that favored speaker to speak on those same topics. So we're censoring one viewpoint and mandating access and information on the same topic from another viewpoint. Just like a previous amendment we were talking about before, all are equal, but some are more equal than others. You know, we went through 1984, now we're an Animal Farm. I don't know what part of the George Orwell pantheon we're gonna go to next, but this bill is a bad idea. It's wrong, it's unconstitutional, but bills that have been passed like this in other states have been challenged. This one is gonna get challenged too. It's wrong, it's unconstitutional. Vote no against this bill and vote yes for Representative McDonald's amendment. Thank you.
Further discussion to the McDonald amendment. Representative Scott.
Madam Speaker, I'm kind of perplexed because on one hand we have the union making someone sit down with someone for 30 minutes, and it's not optional. The language says must. The employee must sit down and listen to something against their will if it's a union. But if it's an employer, they have to tiptoe around their language. That's what is happening in this bill. It's crazy. In fact, I would say it's really bonkers. vote for the McDonald amendment.
Further discussion to the McDonald amendment. Representative McDonald.
Madam Speaker, thanks for the great discussion. I certainly won't repeat what some of my colleagues had mentioned, but I will just put a exclamation mark on what Representative Scott said, that in the bill, in Representative Nelson's bill, and there was amendments to correct it, that their bill does force, must is the language in the bill, that the employees must meet with a union representative, and then also must provide the information. But yet, this bill, portion Representative Berg's, is saying that no, an employer and an employee must not and cannot communicate on important issues that affect life and in their business. That is definitely an infringement on our freedom of speech and the freedom of an employer to work with his employees, his team, to do what's best for their community, be it a civic organization, religious organization, or a political organization. So, Representative Berg, I think most folks would agree that an employer shouldn't force an employee to do this, and if they don't fire them. But your bill certainly will discourage any of that debate and that good, honest discussions to happen whatsoever. And for that's a shame. That's very sad. The National Federation of Independent Businesses, they have over 10,000 employers, businesses, and then the Chamber of Commerce, they have a letter on your desk. They have over 6,300 members. These are the business community that's contacted us, I hope they contacted you, that say this is a very bad provision in the bill, and they don't support it, and they wanted us to fight for them. So we're on behalf of the 6,300 members that are in those groups, we support you, and we will vote to try to strip this provision from the bill. And with that, Madam Speaker, I ask for a roll call.
Representative McDonald requests a roll call. Seeing 15 hands, there will be a roll call. Seeing no further discussion on the McDonald amendment, the clerk will take the roll. The clerk will close the roll. There being 61 ayes and 69 nays, the motion does not prevail. The amendment is not adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File Number 1384, as amended.
The member from Olmsted, Representative Quam.
Thank you, Madam Speaker. And I wish this bill included some creative, innovative ways of helping the economy, that Minnesota could be a leader. Frankly, we need workers in our ag industry. We've been very prevalent at copying or trying to exceed California. And I had shown the chair a bill before I dropped it, hoping to get a hearing. I didn't offer it as an amendment because it actually requires some good committee work. And I started with this back when our governor was a congressman, looking at how we could have enabling language federally and locally. And the idea is we need workers in the ag industry. There are a lot of people that would like to have legal status to work in Minnesota. So I've been trying for years to have it so that we can have an extended allotment or a waiver, basically to allow us to have guest worker visas to bring people in and help in the industries that need it. And frankly, that legal status is wonderful because then they would no longer owe anything to, whatever group helped them get in. They wouldn't have to worry, and it'd be easier for them to be in the community. And we would gain because it's often difficult in the ag industry in greater Minnesota and many industries to get workers. And I think it'd be a win-win. But it would require actually getting committee hearings and looking at how we could lead the nation in a better way of approaching a big national issue. So I'm sorry that it wasn't allowed a hearing, but hopefully in the future we can do that, because we're covering a lot of the same old stuff here. We need to think new and innovative. Plus, we need to stop getting into these battles over, I still don't understand why we don't have an opt-out, because just the thought of their data leaking out scares some of these people that have gone through what they've gone through. But hopefully the chair will be open maybe next year to holding a hearing and having Minnesota actually lead in an area instead of hashing over the same old, back and forth that we heard today.
The member from Wright, Representative McDonald.
Madam Speaker, we really need some more recyclable pails over here. There's nothing over here. Thank you, Madam Speaker. You know, Representative Nelson, there are some good provisions, or decent provisions in your bill. We're not going to be a Debbie Downer on everything. But there's enough provisions in the bill that are really harmful to businesses, and yet more unfunded mandates and more cost to our employers. And it'll give more cause for our neighbor, Fargo, and our friend, Mr. Wonderful, I mentioned it earlier, Kevin O'Leary, who was recently interviewed just 2 weeks ago and said the differences between Fargo and Moorhead, Minnesota and North Dakota. And he, unfortunately, and I'd like to disagree with you, Mr. Wonderful, but he said Minnesota was uninvestable. Now that hurts, uninvestable. And Fargo is doing tremendous growth in its economy and in its population, because they're doing something that Minnesota's not. And they're not passing more bills, more mandates, more regulations, more fees, more fines, and making it more difficult to be a successful business entrepreneur, whether you have one employee, 5, 10, or a couple thousand. So unfortunately, Representative Nelson, this bill does exactly for Minnesota businesses nothing. It makes it even more difficult and more expensive, other than those other good provisions that you had in the bill. But it'll just give our states, our neighboring states, another leg up on success with their businesses and their entrepreneurs, because they'll do it for less regulation, less mandate, less taxes, and less fees if you make an honest mistake. So I encourage a vote no on the bill, unfortunately. And with that, Madam Speaker, let's see, I had something else to say, but I forgot. Doggone it, but I guess that's it. So roll call, no, I don't have to roll call. So Madam Speaker, thank you.
The member from Dakota, Representative Berg.
Thank you, Madam Speaker. I want to thank everyone who made the tremendous work that we did for workers this session possible. To our CLA Matt, thank you for keeping us on track, for the moral support and all the mid-committee humor. Thank you to the pages who always had our materials ready and organized. Thank you to nonpartisan staff, Marta James and Anna Sholin, for your extensive knowledge on literally everything. To our CA Travis, thank you for taking me under your wing without ever making me feel like I don't know what I'm doing, for answering my endless questions and ensuring that our committee ran smoothly no matter the circumstances. I'm so grateful that I get to continue to work with you to do good things for the workers of Minnesota. Special thank you to Sully for being such a thorough researcher and consummate warrior who is responsible for us getting it right in the work that we do. Thank you, Chair Nelson, for letting me spread my wings a little to learn and grow. I want to thank Lead McDonald for your respectful leadership. I've really enjoyed working with you, from your thoughtful questions and comments to our good-natured sparring. Thank you to your side of the table for the engagement and mindful questions, and fruitful debate helps ensure that we are crafting the best possible legislation. To Representative Hussein, Representative Kozlowski, Representatives Greenman, Jordan, and Wolcott, thank you for never wavering in your pursuit of justice for our workers. I will fight like hell beside you every time. I'm extremely proud of our labor bill that has centered workers in every word and policy. As you have heard this evening, we strengthened PELRA, prohibited no poaching laws for franchisee employees, so workers can choose the workplace that best suits them. We've expanded the scope of prevailing wage for work on public buildings, authorized churches, synagogues, and mosques to have tiny homes on site to innovate options to address homelessness in our community. We made much-needed DLI changes to OSHA policy and building codes. But I do admit the provision in our labor policy bill that I'm especially proud of is House File 2442, a bill to ban captive audience meetings. This is one of the most effective and widely used union busting tactics. Banning these kinds of meetings is a top priority for our labor partners. And I just want to set the record straight. Captive audience meetings do not ban the First Amendment right. The First Amendment grants freedom of speech without fear of being censored or persecuted. The U.S. Supreme Court has recognized that it is a violation of the First Amendment to force people to listen to views other than their own. This bill protects the freedom of employees not to listen to speech about politics or religion, which are core matters of individual conscience. And to answer the question, the line that cannot be crossed is for the employer to retaliate against the employee for leaving one of these meetings or simply choosing not to attend. Banning these kind of meetings is, as I said, a top priority for our labor partners. Our workers deserve the fundamental right to organize, to collectively bargain, and to have a workplace free from harassment and coercion. This bill simply protects the worker's right to not be forced to listen to an employer's opinion on politics, religion, and of course, being subjected to union busting activity. This bill simply holds employers accountable and protects workers. Last Friday was Workers' Memorial Day. We stood there in the very apropos cold and rainy weather as we mourned the loss of 7 of our workers this past year. That is 7 families that will never be the same. I believe this bill will make progress in keeping our workers safe. Although this is a great bill, we will never stop fighting to make sure our workers are fairly compensated for their work, free from labor trafficking, modern-day slavery, wage theft, for the right to collectively bargain and to have the best safety standards in the nation. It has been my extreme honor to be the vice chair of the Labor Committee this year and to be a part of the historic advances and protections that we were able to make for the workers of Minnesota and their families. Thank you, Madam Speaker.
The member from Morrison, Representative Schultz.
Thank you, Madam Speaker and members. This bill does a few things where our side of the aisle can be at least a little bit encouraged. But on the whole, and for the major points of this bill, this stacks the deck in favor of one side. This bill is the product of the Labor and Industry Committee, and it is the heavy hand that disincentivizes further investment from industry in favor of the other side, labor, pitting people against one another, which is exactly what we see through multiple provisions contained in this bill. And I'll talk briefly about those, but before I do, I just also want to echo the points that were made by Representative Berg in gratitude towards our staff, and especially to add those extra kudos and thanks to our nonpartisan and partisan staff, especially our Republican researcher, Harry Kennedy. But as we look at this bill, the heavy hand of this new legislation is going to come down upon job creators and more specifically, our schools across this state. This bill could have taken more input. This bill could have taken the ideas and the thoughts and the concern of administrators, of school board members, of other interested educators in this state and done a better job to protect their rights and to protect their fiduciary responsibility to our state. But instead, debate was limited. Instead, the voices of Minnesotans was limited. And because of this, we find ourselves with a bill that has very dangerous and concerning legal provisions that could find themselves in court sometime very soon. But at the end of the day, this should be centered around a workforce in Minnesota that works for a healthy balance between labor and industry so that both can thrive. This bill doesn't do that, and it's why I encourage a no vote.
The member from Hennepin, the author of the bill, Representative Nelson.
Thank you, Madam Speaker. And I want to thank Representative Berg. She did a great wrap-up of what's in the bill. I just want to add one thing. When we spoke earlier about the exemptions from load controls, I misspoke. The investor-owned companies that do power, like NSP, are not covered by this. This provision covers co-ops, the munis, and the rural, so that's the small towns out there. Again, this was a good bill. We heard it through committee. It's made up of a bunch of bills from a lot of people. And members, I ask you for a green vote.
The clerk will take the roll on the bill. The clerk will close the roll. There being 69 ayes and 61 nays, the bill is passed as amended and its title agreed to.